Hi, thank you for joining us and welcome to this installment of David W. Klossing's Clarifying Tax Situations.
What are the common issues that you're going to have to deal with if you're facing IRS collection action? First of all, taxpayers that have unpaid taxes with the IRS or Franchise Tax Board will eventually face collection action by both organizations. Real quickly, both organizations have a way of identifying you if you're a non-filer. That can put you in collection actions. I've got a whole series on non-filers. I won't get into that here. Or you can find yourself in a deep hole after facing an IRS audit or some sort of adjustment to your tax returns, either through an office audit, a field audit, or a correspondence audit. But no matter how you face tax debt, it could just be that you haven't been paying enough taxes on an annual basis and a liability has been building up over time. The bottom line in this area is that tax obligations either must be paid or forgiven in some manner, otherwise you're going to face the following: liens, levies, garnishments, penalties and interest, a vicious cycle surrounding penalties and interest, damage to your credit rating, and perhaps the most important concept if you get anything out of this video, you're going to eventually get something from the federal government called the Final Intent to Levy Notice. At that point, a 30-day clock starts ticking. If you don't file some sort of collection appeal within that time period, you will lose significant rights and be at the mercy of the revenue officer or automated collection services agents that are after you. You can lose rights to appeal both the underlying tax liability if you don't agree with the assessments that are sitting there, or the manner in which the IRS is attempting to collect the taxes that you owe them. So, the most critical thing you need to know when facing either a federal or state collection action is that both the state and the Fed are required to give you notice before they can take certain legal actions to start collecting on the taxes that you owe them. The federal government will send you a final intent to levy notice in which you will have 30 days to take an action to appeal their collection procedure, either the way they're going about trying to collect it or the amount of tax that's at issue in certain situations. What taxpayers need to keep in mind about this final notice is that for it to be legally sufficient, all the IRS has to do is send it to your last known address, which would be the address on the last tax return you filed. If you have moved since that date and didn't give specific notice to the IRS, it may have gone to the last address where you file a tax return, and that is legally sufficient to start the 30-day clock ticking. You're not completely out of luck, but there's a different procedure other than the collection due process appeal that we need to talk about. If your issue is with the federal government, you will receive a notice entitled Notice of Intent to Levy, or some sort of final notice about an intent to levy, including your rights to an appeal. You could have also received something called a Notice of Federal Tax Lien. In order for a lien to be effective, it needs to be filed with the county recorder in the county in which you live. If you hire the tax law offices of David W. Klossing to help you with your collection issues, the first thing we're going to try and do is gain the high ground in the collection matter. We want to, if possible, take the power away from the IRS, the revenue officer, or the automated collections department and put the power in your corner. Slow the game down, make wise choices, and come up with the best possible solutions for you. If we don't get this opportunity, you're dancing to the tune of the government rather than trying to work with the government to reach a solution that works for both parties. So to gain control of your matter, we basically have 3 appeals programs that we can choose from. Each has advantages and disadvantages. The first one we're going to discuss is called a CDP appeal, or a collection due process hearing. The second we're going to discuss is called an equivalency hearing. The third is going to be a CAP appeal. A CAP is a collection appeal program. Okay, so let's first talk about collection due process hearings. In order to request a collection due process hearing, the taxpayer needs to file Form 12153, which is a request for a collection due process hearing. You must do this within the 30 days of receiving the IRS's final intent to levy notice. The first thing this does for us as your attorney, as your law firm, is it protects the specified tax periods enumerated on the final intent to notice document from further collection action until your appeal is heard. It freezes the collection department. This can be a freeze for up to 2 months, in which time we have time to get your house in order, time the revenue officer oftentimes won't be willing to grant to you, that we can make your case in appeals. In order to get a lot of these appeals options in place, we have to have you in full compliance. A lot of times the revenue officer has lost patience with you. They've given you notice after notice, and for some reason you haven't managed to get in compliance. The time ticking for the 2 months can give us the chance to get you in full compliance so that when we do face appeals, we can get you a better resolution to your matter than the revenue officer was offering you. The cold hard fact of the matter here is if you owe more than $50,000 to the IRS, they do not have to grant you an installment agreement. They can resort to aggressive collection action, including levies against any asset that is liquid. First thing they look to is cash accounts. They can look to retirement accounts. They can look to your Social Security. They can look to, if you have 4 cars, 3 of them are collector's editions, they can grab those cars and sell them at auction and take that money. If you have a boat and that's an asset they could grab, there's lots of things they can do, and you may not be happy about it. Sometimes the only way to stop the revenue officer from taking an action that you don't agree with is to tie their hands procedurally by taking it away from the revenue officer and taking it to the appeals department. Kind of shuffles the deck. The second thing that filing a collection due process hearing does for you is it secures the right to take your issue to court if you don't agree with the deal that you strike with the appeals department concerning your collection action. If appeals says we're going to take your assets and you don't want them taking your assets, you may be able to get a better deal by taking it higher up the ladder to a court. One big negative thing that a collection due process hearing does is it freezes the 10-year collection statute. Ordinarily, the IRS has 10 years to collect an outstanding debt from you. If it isn't paid within those 10 years, unless they reduce that amount to judgment, it becomes non-collectible at that point. If you file a CDP, that 10-year statute freezes while they're considering your appeal. Until it bounces out of appeals back into collections, that 10-year clock isn't running. When you finally get to appeals, your attorney needs to make all arguments as to why they disagree with the proposed action of the revenue officer and what collection alternatives would work for both the government and the taxpayer. In other words, what are your proposed collection alternatives? When you get to appeals to argue the collection issues, if you can't reach resolution with appeals, they're going to issue a notice of determination. At that point, after receiving the notice of determination, you have 30 days to file a tax court petition in order to move the collection issue out of appeals and into a court. Now, if you get nothing else out of this video, the failure to file a collection due process appeal or hearing within that 30-day window causes lots of problems. Number one, you lose the right to take your issue to federal court if you disagree with the resolution reached in appeals. You lose the opportunity to temporarily tie the hands of an overly aggressive, sometimes, in my opinion, abusive revenue officer and gain the high ground. You can lose the ability to negotiate a more palatable collection option. In other words, you might have to take what that revenue officer is demanding rather than reaching an agreement that's more palatable to you. Keep in mind the $50,000 complication. If you owe more than $50,000, the government doesn't have to give you a lot of the collection options. They have the high ground to dictate the collection options that they want, not the collection options that are acceptable to you. To get the best result, you really need a tax attorney in situations where you owe over $50,000. The next way an attorney can attempt to take control over your collection issue is through an equivalency hearing. Ordinarily, our office prefers CAP appeals or CDP appeals over equivalency hearings, and I'll explain why. If you file a CDP appeal and it happens to be after the 30-day notice period is run, you're automatically bumped into the equivalency hearing procedures. To qualify for an equivalency hearing, you need to be after 30 days from the issuance of that final intent to levy notice, but within 1 year from the issuance of that final intent to levy notice. When you're granted an equivalency hearing, the case will still be forwarded to appeals, but there are some distinct differences. I find them advantageous, so do most tax attorneys, as opposed to other procedures. The biggest disadvantage with an equivalency hearing is that the revenue officers or automated collections department's hands are not tied while the appeal is being heard. This can be up to a 2-month time period before they even hear your appeal. During that time period, that 2 months or longer, that revenue officer is free to bring forward any collection alternative they desire, including grabbing your assets, selling them, posting up public liens, entering into wage garnishments, which your employer gets knowledge of. By the way, liens are public notice. It'll affect your credit rating. Lots of bad things can happen. This is why it's so important to file within that 30-day period and get a CDP procedure rather than an equivalent hearing. An equivalency hearing is normally granted fairly quickly. When you get there, you better make sure your house is in order, that you're in full compliance with the law, that you've got all the information that the appeals officer is going to need to see to decide in your favor, because you really don't have the high ground, and that appeal officer knows that if you don't like what they have to hand you, you have no tax court or any type of jurisdiction of a court to take it to. Appeals word is final. They tend to not work as well with you when you don't have the high ground. When you get to appeals, they're going to check your record of compliance. They're going to check that you've provided all the information they need to make a timely decision, and then they will consider your alternative collection methodology, but they may not grant it. If you go to appeals again and you don't like what they're giving you, you have no right to go to court, and as soon as appeals issues the decision, you're back down to the revenue officer or automated collections department that you were dealing with prior to filing the appeal hearing. One positive thing to say for an equivalency hearing is that unlike a CDP appeal, the 10-year clock does not get stopped during the period where appeals is considering your position. The last action that an attorney can take to try and grab the high ground in a collection action is a collection appeal program request. I can use a collection appeal program request to appeal many of the collection actions desired to be taken by the IRS that you find unpalatable. The way you go about requesting a CAP appeal is by filing Form 9423. The collection actions taken or being proposed by the IRS that can be appealed via the CAP procedures are as follows. A notice of federal tax lien that is about to be or has been posted to the public record. A levy against your bank account or other property that has been or soon will be taken. A seizure of your property where the government grabs the property from you with the intent to sell it either at auction or some other methodology. You can sometimes recoup that property through this procedure. This procedure can be used to subordinate a lien or to request a withdrawal of a public lien. This procedure can be used to request to issue lien certificates, such as a lien subordination, a lien withdrawal, or a lien discharge, or non-attachment of a lien, especially when this has been denied. This procedure can be used to attack a proposed or actual rejection or a modification or termination of an existing installment agreement. Finally, it can be used to go after a wrongful levy. An attorney must make his taxpayer comply with certain procedures before utilizing a CAP. This differs depending upon whether the client is in front of a revenue officer or in front of automated collection services. If the taxpayer is in front of an RO, he is required to do the following. The first required action is to inform the revenue officer that you disagree with their proposed collection action and you're going to appeal that decision. The taxpayer is required to explain why they disagree with the proposed action and offer alternative solutions. If the issue can't be resolved directly with the RO, the taxpayer or his representative must escalate the issue to the RO's manager. After speaking with the auditor's manager, the taxpayer and his representative have 48 hours to file the Form 9423 to get into the collection appeal program. If the taxpayer is appealing the rejection of a proposed installment agreement or the proposed cancellation of the existing installment agreement, they're required to do the following. The taxpayer has 30 days to file Form 9423 after receiving notice from the IRS that they are rejecting the proposed installment agreement. The taxpayer has 76 days to file 9423 after receiving notice that the IRS intends to terminate an existing installment agreement. In any case, the installment agreement in existence will terminate within 45 days of the notice of intent to terminate the installment agreement. What are the differences between a CDP and a CAP appeal? Each procedure has advantages and disadvantages. Your tax attorney will know which procedure will benefit you the most and bring your risk of a bad result down to the lowest level. One distinct disadvantage in using a CDP is where the issue is a lien. By the time the issue is heard, the lien will already be a matter of public notice and will have negatively impacted your credit rating. Another disadvantage of a CDP is that it takes months to get through this procedure rather than weeks with a CAP appeal. A distinct advantage of the CDP over the CAP procedure is that it ties the IRS's hands as to collection actions, both proposed and actual, while the appeal is being heard. This is the reason our office favors them. This gives you the ability to be heard by appeals without the negative enforcement action being taken against you before your issue is heard. The biggest advantage is that it also preserves your right to go to court if appeals won't work with you and you can't reach an alternative collection methodology that works for you and the IRS. One distinct disadvantage in using a CAP is that if you take your issue to appeals and you don't get a resolution to your issue that you can live with, you're bounced right back into the collections, possibly back to the revenue officer that you're complaining about in the first place. And furthermore, you have no right to go to court to contest their collection action. Where I find CAP appeals most advantageous is where the 30-day notice period to file a CDP appeal is ticked and I'm facing some action that the IRS is going to take that's detrimental to my client, and I still need to be able to grab the high ground and tie their hands. For example, if you're facing a wage garnishment, bank levy, or a public lien, it's possible to tie their hands before that action is taken through a CAP appeal. So CAP appeals are really useful when you want the issue to take weeks rather than months to deal with. If you're after that 30-day notice period, this may be the only way to halt a proposed collection action that you can't live with. This includes the posting of a public lien, a wage garnishment, or the cancellation of an existing installment agreement. Just to reiterate, if you file a CDP request after the 30-day period, it's going to revert into an equivalency hearing. In equivalency hearing, the IRS's hands are not tied while your issue is being considered by appeals. In a CAP, the IRS's hands are tied while the IRS Appeals Division has a chance to make a determination on your issue. What are the consequences for failing to work out a plan to pay your back tax debt? The first action the IRS is going to take is to post up a public lien in most circumstances. This gives them collection priority against other creditors that you may owe money to in the event that you go bankrupt or forced collection action is pushed upon you. A lien affects your credit rating negatively. It will be on your record for a minimum of 7 years to a maximum of 10 years. The entire time it's there, it will have a negative effect on your credit rating, making it hard to do things like buy a car, get a bank loan, get a credit card, even apply to rent something. A tax lien is a matter of public record. It contains your address, how much money you owe, what relevant tax periods you had a problem in, and it's a matter of public record. This could be truly embarrassing and will lead to an avalanche of junk mail. Let me warn you right here and now, there is a cottage industry of rip-off artists that are practicing in the IRS collection, matter of fact, state collections arenas. Oftentimes, all they're looking for is for you to pay them a $3,000 flat fee, and their intention is to do nothing about your problem, or most of the time they're looking to do what's called an offer in compromise. They're going to submit some paperwork to the government knowing full well that your offer is going to be rejected. Why? Because they want the $3,000. My office will not take your issue unless we think we can help. We are ethical and honest. We have an A, Better Business Bureau rating. I have a 10 rating as an attorney. I have an excellent reputation with the taxing authorities, and I'm not here to rip you off or make your problems worse. This cottage industry of rip-off artists buys lists that are published by companies that collect this information on liens. You'll get bombarded with more junk mail when you owe the government money than you've ever seen in your life. They may even call you at work. They may even show up at your house to try and earn your business. They may even say nasty things about me to get your business. The next embarrassing thing that can happen to you if you ignore your tax debts is the government can secure a wage garnishment against you. That is when they send notice to your employer that says, hey, don't send Sally her check. Take half of it, send it to me, send her the other half until the tax debt that she owes the federal government is paid. This is embarrassing. Your employer now knows you have tax problems. What brings a lot of taxpayers into my office are bank levies. Bank levies are where the IRS goes in and grabs whatever balance exists in your account on a certain date and time. Ordinarily, that account balance is frozen for 21 days. Any checks written on that account are going to bounce. You don't have access to that money. That account is frozen for 21 days. Then the balance that existed on that day is remitted to the taxing authority. However, it is possible to head that off at the pass. It's also really infuriating when your federal or state refund that you're counting on when you file your taxes is grabbed by the taxing authority and applied towards back tax debt. That brings a lot of people in my office as well. The next really embarrassing thing is when the IRS comes in to seize some of your property. All right, if you own 4 cars, one of them is used for transportation, 3 of them are collector's edition cars, they could roll up with tow trucks, tow them off, and sell them at auction to the lowest bidder to pay off your tax debt. Most people come to me worried about losing their primary residence. I will tell you this, it takes a court order for the government to take your residence and sell it if it's your primary residence. It generates a lot of bad press. They really don't like to do that. Left unaddressed, a tax debt issue can drain your cash accounts, it can drain your investment accounts, it can drain your retirement accounts. They can even come after 15% of your Social Security if that is your sole source of income. And the worst part of all this, and this goes for the state and federal governments, I tell my clients this all the time, the government is the only creditor on the planet that has the power to force you to live at the poverty level. You can have $38 million of income coming in a year, and they can force you to live at $18,000 roughly in California of income a year, because that will put you at the poverty level until you've repaid them. That's if you do nothing about your issue. Another complication that brings clients into my office is when they're attempting to either buy real estate, sell real estate, or refinance real estate. If there's an IRS lien in the works, this can screw everything up. First of all, if you're attempting to sell real estate that has an IRS lien on it, the buyer is going to be very concerned about obtaining clean title to that real estate, and ordinarily they're going to want that lien removed before they move forward with the buy. If the buyer can get past the issue of clear title, realizing that the government is just going to grab proceeds out of escrow to satisfy its tax debt, it sure is disappointing to a buyer to be expecting $300,000 of cash on the sale of their property and walk away with a substantially lower figure while the government satisfies its tax debt with the proceeds from the sale of your home. It's impossible to refinance a home that has a lien on it. The reason for this is the lender is not going to be willing to refinance your home unless the mortgage is in a superior position to the IRS's lien. This is possible, but the IRS has to be willing to subordinate its lien to the new mortgage in the refinance. For this reason, I can oftentimes get the government to work with you to allow you to refinance your home so you can find the proceeds to pay them back out of the value or the equity in your home. You need to realize the IRS is under no obligation to get out of the way of your refinance by being willing to subordinate its lien to the new first mortgage on your property, even if your intention is to take the refinance proceeds out of the deal and pay off what you owe them. Another issue that brings taxpayers into my office is where the IRS has posted up a public lien that is negatively affecting the taxpayer's credit rating. The most straightforward way to have a lien taken off the public records posted by a taxing authority is to pay them what you owe them. However, this approach is only appropriate where, number one, you approve of the amount of tax debt that's sitting there, and number two, you have the funds available to pay them. There are other methodologies to address that tax lien. As your attorney, I can attempt to have the lien discharged. Ordinarily, a lien discharge is necessary where you need to obtain clear title to sell your property. If your intention is to use the proceeds out of the sale of this property to pay the IRS what you owe them, they typically will allow you to do this, but they're not required to. However, even if a lien is discharged against your real estate, for example, it still is in effect as to any other asset in your name. As previously discussed, the IRS may allow a lien to be subordinated to another creditor to get out of the way of a refinance. Having a lien withdrawn by the IRS is a big win legally because it's as if the lien never existed afterward. A lien withdrawal is accomplished by filing Form 668Y and will only be granted after the taxpayer has met certain obligations. So, what are the potential solutions that a tax attorney can bring to the table when you're facing a collection action? The first option that everybody's heard of is called an offer in compromise. This is where the government determines your reasonable collection potential. In other words, how much blood is in the turnip? If they squeeze the blood out, how much blood would they get? Reasonable collection potential is exactly that. Based on your net worth and your earnings both now and in the future, how much can you afford to pay rationally? If you owe the government $30 million and your net worth is $1, and your net income for the next 10 years is $10,000 a year, who's got a bigger problem, you or the IRS? Are they ever going to see that money? Listen, they realize this. The only reason they'll do an offer in compromise is to reduce your liability to a number that makes sense so they don't waste their collection efforts. First thing I need to tell you is less than 1 in 5 offer in compromises are accepted. The next thing a tax attorney can analyze for you is an option called tax-motivated bankruptcy. Now this is high stakes poker here, and you really need to bring in a tax bankruptcy attorney to finalize the analysis. My firm at least knows the high spot issues and can do an initial analysis of your availability of this option. In order for debt to be dischargeable under bankruptcy, it needs to be accrued on the books and assessed for 2 years before it can even be discharged. The second requirement is that all debt that's going to be discharged comes from timely filed returns. If you're trying to discharge debt related to a substitute for return, even if you amended that later on, that's a late filed return and is non-dischargeable in bankruptcy. The next thing has to be looked at is what type of bankruptcy is going to stop the IRS dead in its tracks. If you own a business, you may need a Chapter 11 to stop them from collecting at the business level, and you may need an individual bankruptcy to stop them from collecting at the individual level if taxes are involved, like trust fund taxes, for example. Tax debt in bankruptcy can either be wiped away completely under Chapter 7, or a court can dictate a required repayment arrangement to the IRS under a 13. Innocent spouse relief. This should be a slide series all on its own. It's very complicated, but the basics of it are this. If your spouse has been cheating on their taxes and you have not been a participant in that cheating, and you learn of it, it may be possible to, at least as far as the IRS is concerned, have the tax debt coming out of those motions of cheating specifically allocated to the cheating spouse. So they won't be collecting against you, they will be collecting against the spouse that cheated. But I will tell you this, it's very hard to collect alimony from someone that's in a jail cell, It's also very hard to walk away with a marital settlement on 50% of your community property if that community property is evaporated paying towards fraud. This isn't a decision that should be made lightly, but it is a collection alternative. Installment agreements. Ordinarily, if you owe less than $50,000, you automatically apply for an installment agreement if you follow the correct procedure. If you owe more than $50,000, the government does not have to give you an installment agreement. It may take a tax attorney to get you one. Currently non-collectible. It may be possible to get the IRS to look at you and say, you know what, they have no net worth, they have no current net income, they're currently non-collectible, let's stop all collection action until they either have some assets that we can go after or some income we can go after. What you need to know about currently non-collectible is that the interest on the underlying tax debt continues to accrue. Right now the rate is 3% compounded daily. It's roughly 9% simple interest a year on the underlying tax debt. Writing out the 10-year collection statute. It may be possible to write out the statute after 10 years has passed on an assessed debt. That portion of the debt is no longer collectible under the law unless the government goes to court and reduces it to judgment, which they rarely do. You need to know there's a 10-year collection statute federally, but in California there's a 20-year collection statute. Online payment plan. If you are an individual and you owe less than $50,000, in most circumstances it is possible to get you a 6-year spread on what you owe. Take the total amount you owe, divide it by 72, that is your monthly payment. If you're willing to make that payment by letting the IRS come in and take the money electronically from your bank account once a month, it's possible to automatically get acceptance into this program. Also, if you make 3 of those payments timely, it's possible to get the government to remove the lien related to that tax debt. To get an online payment plan, you must be in full compliance. On a go-forward basis, you must make your estimated tax payments as they come due, you must file your taxes timely as they come due, and you must stay in compliance. Also, to qualify, none of the tax debt at issue can expire within 6 years on the 10-year collection statute. In other words, if they allow you 6 years to pay back your tax debt and some of that tax debt is going to fall off because of the 10-year collection statute, this may cause that plan not to work. There is an express version of the business online payment plan where the tax debt is $10,000 or less. This is accompanied by relaxed application procedures, including the possibility of not having to supply financial statements. Again, it's a 2-year repayment period. So here's my conclusion to all of this. The average person spends between 30 and 50% of each dollar they earn towards the current year's taxes. Now, if the government comes in after the fact in a collection scenario and demands that you take 25% of every incoming dollar and start servicing the back tax debt, look what that does to you. This leaves you with between 25 cents to 45 cents of each incoming dollar of current year income to support your lifestyle. So I'm going to end this collection series video with talking about situations where the IRS is not likely to be sympathetic to your collection problems. And in that situation, you need a tax attorney on your side more than ever. You're likely to find the IRS non-sympathetic when you're a non-filer. If you've been out of the system for several years, especially where the government has gone through and prepared substitute for returns, and then you've had to fight with them to replace those substitute for returns with actual returns. When you finally get to the collection side of this problem, you may not find them very sympathetic. You need a tax attorney on your side. Besides, non-filing in itself is a crime. You need to see my series on non-filers if that's your situation. If the underlying tax debt results from an audit where you were at fault, especially where there may have been badges of fraud or where fraud is suspected, you may not find the IRS very sympathetic to your collection woes. If you've gone through either an offshore or domestic voluntary disclosure, you may not find the IRS very sympathetic to your collection problem. If you, at least on paper, show the present ability to pay every dime of what's owed, you may not find them very inclined to give you something like an installment agreement and spread it out over a number of years. They may want their money now. In that case, you may need a tax attorney. They'll be looking at your retirement funds, your equity in your home. They'll be looking at any present asset that can be grabbed, turned into cash, and used to pay off their tax liability. Again, they want their money now, not spread over 5 years, 6 years. If you have a history of not making estimated tax payments or making insufficient estimated tax payments, or in claiming multiple exemptions so that insufficient withholding is taken on your W-2, which could be a crime, by the way, you may find a very non-sympathetic collection officer. If you continually break promises that you make to the IRS automated collection services or to a revenue officer, you may find them unsympathetic. This includes repeatedly breaking installment agreements that you arrange. If you have insulted or alienated your revenue officer, if you've gotten hostile with them or blown them off saying you have no power to affect me, you may find them non-sympathetic. You need an attorney more than ever in that situation. If you've been commingling your business and personal assets to maintain your lifestyle, in other words, having your business pay your living expenses, you may find them very upset with you. If you've repeatedly refused to respond to information requests and not given them the information they need to figure out your ability to pay and work this issue out, you'll find them very unsympathetic. If you're a repeat offender, especially with the same revenue officer, she thinks she has you out of her inventory and you keep popping back up in her inventory, she's dealt with you multiple times, you'll find them get very short with you after a while. If you're a tax protester and it's known to the IRS, oh boy, they won't be sympathetic to your collection problems. The last thing I need to tell you is that there are many potential felonies that are possible to incur in a collection scenario. If you owe the IRS money and you do things like hide your assets in other people's names, sell your assets, your valuable assets, to a neighbor down the street for $1 with the intention they're going to give it back to you, creating multiple corporations and walking away from tax liability, corporation after corporation after corporation, lying to a collection officer, hiding assets, moving your assets offshore to a foreign jurisdiction, any of these actions can put you in jail. If that's your problem, you need me more than ever. I have a lot of experience dealing with these type of issues. Thank you for watching this video.
Thank you so much again for your time and interest in how we may be able to help you. Please don't hesitate to call if something is worrying you. We would be very happy to help. Just call or email for a reduced rate consultation.